point is that the Ohio Supreme Court has recognized the importance of releasing jury questionnaires and names of jurors. And the reason why is because we as the public are all watchdogs on judicial proceedings. And one of the watchdog roles is the jury that's being impaneled, are they fair and objective? That's just one issue. Did they decide the case fairly? Having open courts, which includes information about the jury, allows the public to assess for themselves whether there's been any deviation from the administration of justice in a fair and objective way. Has a jury been impaneled all from one neighborhood? Does a jury represent, is it really a jury of the defendant's peers? There are many issues that are raised, or there are many issues that the public is allowed to understand more fully when the court process is open to the public. And part of that openness is releasing jury questionnaires unredacted. And the Ohio Supreme Court has endorsed this concept. This is not something that the media or WCPO has invented. This is something that courts across the country have recognized as an important foundation to our free democracy, that the public understands how jury trials are administered, especially in criminal cases, especially in high-profile criminal cases. It's important for the public to understand everything about what's going on in that courtroom.
And then we're going to get them redacted tomorrow.
Yes.
Right?
Yes.
Does that do much to tell us? I mean, you talk about finding out what neighborhoods. We're not going to find that.
Well, we'll wait to see what redactions are made, and we'll decide the next step after that, after we see the redacted questionnaires.
How do you feel about that decision?
The judge is certainly free to make the decision that the judge made. I disagree, obviously. I objected a number of times, and I don't think that the standards set forth under Ohio Supreme Court case law have been met here. There has been no particularized finding of any danger to any specific juror. There have just been generalized comments about concerns, and that's not enough under the case law to redact questionnaires or to seal them entirely.
I want to go back to this public perception thing. This isn't a case of we want everything we want. It's a matter of law.
It is a matter of law. There is plenty of case law across the country under the First Amendment to the United States Constitution that jury questionnaires are presumed open unless a compelling reason can be found to close them. And here we argued that no compelling reason has been found. I don't want to go too far off the reservation here.
I mean, this isn't us trying to be invasive. This is...
No, it is the media taking on its well-established role as watchdog of government, which judicial branch courts are a branch of government, and the media serves the public function of representing the public in understanding court process, being the watchdog over the administration of justice, and making sure that everything is done fairly. And understanding the makeup of the jury is fundamental to that process.